application thereafter of bond and bail and the refusal by the ODPP that the accused should be denied bail and bond. This same court, out of empathy in open court, went further and on humanitarian grounds ruled on the said application and even going further to reduce the bond and bail on what could be afforded by the accused person, whom the court was told was a senior citizen and a lot of health complications. It is quite interesting, after the close of the prosecution case, all sorts of insinuations, body language, conclusions of a judgment being meted, and of course, against the accused has been alluded to. Yet the complainant herein had not said anything about the same. Was the court expected to acquit at this ruling stage? A lot has been mentioned about other cases in this application, which are alive cases and cases in other courts. What is the court meant to do under the circumstances, considering that all the mentioned cases are in higher courts? This court empathizes that ignorance of the law is no defense, and mind games can better describe their vermins. I choose to mentor counsel's hearing than otherwise, albeit the choice of words used herein. The application is intimidating, with emotions all to one loop. The defense has been given a chance to state their case, but instead it has been adjourned. It has been an adjournment after adjournment, and then the said grounds meted and analyzing, and I quote, writing their own judgment known to counsels and their clients. The said defense case is still ongoing. The said applicant has been given a chance to prove his case, but not to intimidate as the case may be. It's astonishing to accuse the court that the said court is aware of similar case at the higher courts. Counsels are still being mentioned to learn and unlearn, and this is so much in order. Counsels are taught in law school the etiquette of professionalism, but not to bully courts. I still opt to mentor counsels on this part of our daily learning processes. Ironically, the application is of one accused person, yet there are two accused persons in this case. Why is a narrative being occasioned? What is the ultimate of this narrative? The court takes judicial notice that while there is no stay order, underline the word no stay order, as per today, the 23rd day of October 2025, from the said cited courts by counsel for the accused person, the court cannot on its own motion stay its proceedings. This is a magistrate's court. Seemingly, the parties herein, specifically the first accused parties, are intentionally playing victim, and this commenced immediately accused one was put on his defense. It's quite sad to note that from the onset of this matter, the first accused person has sought adjournments. It was the cause in delay of this matter. This again is replaying itself, and sadly so. It is now in common knowledge that the tactics being used herein are what first accused is using to intimidate the court within and without. The judiciary is a totally independent arm of government, as stipulated in the Constitution 2010. The court is alive, and this matter is sub judice and does not stay orders. Asking the court to recuse herself must meet the criteria to do so. Most importantly, these are issues which need legal recourse. This court will be bigger than the assertion deponed by counsel and his client. Has this court been served with a stay order up to now? No. If the above are to make the court look bad, I emphasize in the same breath that counsel herein should express professionalism when penning down the thoughts of his client. Be kind as a professional and always uphold the rule of law while engaging. Clients come and go, but as lawyers practice is the constant north. This court cannot stay its own proceedings because parties have scored my proceedings to be below par, or so to speak. This court cannot dislike itself because parties do not like body language, and I quote your words, but this court is under oath of office to be above all allegations as the case may be, and this is what I uphold before God and the office that I hold. In a nutshell, the application is properly executed to intimidate. The court will be careful not to be annoyed with counsel or his client, but express mentorship that counsel should be above board and stable before penning such allegations, which literally are his self-lamentations. We have read and seen our names being dragged into public gallery, but we choose the oath of office. We have been discussed in Parliament, but we are not politicians. We choose the oath of office and the Constitution. Now we have been mudslung as the application hearing. Maybe, but again, we choose to affirm the oath of office, the Constitution, the rule of law, and above all, God. Having said the above, two issues stand out in this application, which has basically been mentioned above. Can it take 2 years for this court to have towards the tail end that the said allegations are made? Is it properly sound to bring this application when the said applicant is now on his defense? This case has 2 accused persons, yet only 1 accused person has brought this application. This is notably not the highest court of the land in Kenya, but the initial lower court. In view of the foregoing, and I quote, on the recusal of judges and judicial officers, the Judicial Service Commission made the Judicial Service Code of Conduct and Ethics, Regulations 2010, pursuant to Section 47(2)(a) of the Judicial Service Act, Section 37 of the Leadership and Integrity Act 2012, and Section 1 of the Public Officers Act 2003. Under Regulation 21A, a judge may recuse himself or herself if any proceedings in which his or her impartiality might reasonably be questioned where the judge is, and for purposes of this matter, judicial officers. 1. Is a party to the proceedings. 2. Was or is material witness in the matter in controversy. 3. Has personal knowledge of disputed evidential facts concerning the proceedings. 4. Has actual bias or prejudice concerning the party. 5. Has a personal interest or is in a relationship with a person who has a personal interest in the outcome of the matter. Number 6, has previously acted as counsel for a party in the same matter. Number 7, is precluded from hearing the matter on account of any other sufficient reason. Number 8, or a member of the judge's family has economic or other interest in the outcome of the matter in question. Regulation 21(2) requires that recusal by a judge or judicial officer shall be based on specific grounds to be recorded in writing and as part of the proceedings. This is supplemented by Regulation 21(3), which forbids a judge from recusing him or herself if the circumstances set out therein. The said regulation that the court must guard against its independence and not to recuse itself in circumstances that do not merit. However, in the circumstances where there is a merit, either due to surrounding facts or appearance of bias, a judge should recuse him or herself. If, for example, a family member is involved, the court should not wait for an application for recusal. This even occurs in cases where the judge's conscience points to a discomfort due to a relationship, either legal or otherwise. However, where there is no merit and the same is based on unfounded speculations, the court should and must not recuse itself. Under the Regulation 7 of the Judicial Service Act and Conduct, Regulations 2020, a judge or judicial officer shall exercise judicial authority independently and shall 1. Uphold the independence and integrity of the judiciary and the authority of the courts, maintain an independence of mind in the performance of judicial duties, take all reasonable steps to ensure that no person, forum, or organ of state interferes with the functioning of the courts, exercise judicial function on the basis of the judge's own assessment of the facts of the case in accordance with the conscientious understanding of the law and without reference to any extraneous nuances, and exercise judicial function without being influenced by personal feelings or prejudice or bias. Independent exercise of judicial authority is affected by bias or ill will against a party. It is also compromised if the court succumbs to machinations and intimidation by parties. However, where a party wants to waste the court's time or otherwise forum shop, the court should be firm and clearly indicate so to parties. Unnecessary application for recusal is an affront to the independence of the judiciary and the judicial independence of the judges or judicial officers. On the other hand, a bias court is also noted. In the case of the National Water Conservation and Pipeline Corporations versus Rujji and Partners Consulting Engineers and Planners Limited 2021, the court stated as follows. I cannot think of a more eloquent exposition of the law than others. versus South African Rugby Football Union and others, which indisputably articulated the proper approach as follows. The question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not administer justice without fear or favor and the ability to carry out the oath by reason of their trainings and experience. It must be assumed that they can disabuse their minds of any relevant personal beliefs or predisposition. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. On the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant for apprehending the judicial officer, for whatever reason, was not or will not be impartial. The test is that absolute neutrality is something of a chimera in the judicial context. This is because judges are human. They are unavoidable the product of their own life experiences, and their perspective, thus derived inevitably and distinctively, informs each judge's performance of his or her judicial duties. But colorless neutrality stands in contrast to judicial impartiality, a distinction the above-cited decision vividly illustrates. Impartiality is that quality of open mind, read persuasion without adherence to either party or to the judge's own predilections, preconceptions, and personal views. That is the keystone of a civilized system of adjudication. Impartiality requires in short, a mind open to persuasion by the evidence and the submissions of the counsel, end of quote. And in contrast to neutrality, this is an absolute requirement in every judicial proceeding. This is because a cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before courts and other tribunals. Nothing is more likely to impair confidence in such proceedings, where on the part of litigants or the general public, than actual bias or the appearance of bias in the officers who have power to adjudicate on disputes. In the Attorney General of Kenya versus Professor Anyang' Nyong'o and 10 others, ESCJ application number 5 of 2007, the court stated, and I quote, "We think that the objective test of reasonable apprehension of bias is good law. The test is stated variously, but amount to this: do the circumstances give rise to a reasonable apprehension in the mind of the reasonable, fair-minded, and informed member of the public that the judge or judicial officers will not apply his mind to the case impartiality. The test is not what the litigant feels. It is a member of public who is not only reasonable. In the case of Rachonyo and Rachonyo Advocates versus the National Bank of Kenya Limited 2021, Justice D.S. Majanja, and may soul rest in peace, held as follows, and I quote, "In Philip K. Tunoi and another versus the Judicial Service Commission and another court civil application Nairobi, number 6 of 2016, EKLR, the Court of Appeal adopted the test of recusal propounded by the House of Lords in Porter versus Magill, 2002. The question is whether the fair-minded and informed observer have considered the facts, would conclude that there was real possibility that the tribunal was biased, end of quote. The same position was taken by the Supreme Court by Ibrahim J. in Jasbir Rai and 3 others versus Talokan Singh Rai and the 4 others, Supreme Court of Kenya petition number 4 of 2012, where he observed, and I quote, "The court has to address its mind to the question of whether reasonable and fair-minded mind sitting in court and knowing all the relevant facts would have a reasonable suspicion that a fair trial for an applicant was not possible. If the answer is to the affirmative, disqualification is inevitable. In this matter, a fair-minded, knowing the circumstances of this case, will not have any doubt that the case will be heard fairly." Now, the application for recusal hearing is based on speculation, conjecture, sheer paranoia, and falls short of the legal threshold to recuse from handling the case. Again, in Justice Professor Dr. Sifuna, in Bituman Limited versus SBM Kenya Limited and another 2003, unreported, stated as follows, and I quote, The bedrock of this determination rests on that the recusal is necessitated where it is proved beyond peradventure, speculation, conjecture, and sheer paranoia that a judicial officer will not impartially handle a case before him as a result of actual bias or a reasonable apprehension thereof, and never on unfounded or unreasonable apprehension. Where an application is based on apprehension rather than actual bias, the apprehension should be that of a reasonable person and must be assessed in the light of the true facts as they emerge at the hearing of the application. In the Supreme Court of Uganda, in Uganda Polybags Limited versus the Development Finance Company Limited and others 1999, was of the view that litigants have no right to choose which judicial officer should hear and determine their cases, since all judicial officers take oath to administer justice to all manner of people impartially, without fear, favor, or ill will, and the oath must be respected. The case applied in all cases of apparent bias was whether having regard to the relevant circumstances. I cannot think of a more eloquent exposition of the law on the recusal of judicial officers. And the other is inbuilt aspect of the test is that, and I quote, absolute neutrality is something of a chimera in the judicial context. This is because judges, as I've said earlier, are all human. A cornerstone of any fair and just legal system is the impartial adjudication of disputes which come before courts and other tribunals. Having said the above and cited the above legal authorities, all in the superior courts, within and without the court, orders as follows. Number 1, the said application for recusal is disallowed and the said accused continues with his cross-examination, that the court will give 2 dates for the conclusion of the defense hearing of this matter. This court so submits. And before I pen off, and with finality, this case has been during my pendency when I was recently promoted as a chief magistrate, and this speaks volumes, and equally nominated as the Judicial Officer of the Year award. Has these 2 bodies been compromised to align with the said allegation? Absolutely not, but we mentor the legal profession moving on. The rule of law proceeds. This ruling is read and delivered in open court this 23rd day of October 2025 at 9:30 East African time.
Your Honor, we are most obliged by that ruling. However, I would wish the following to go on record.